All right, good morning, everyone. Good afternoon, good evening. This is our third live stream on our English language channel. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at I.S.Law Firm. We're going to talk about different immigration topics today, and I will briefly make any announcements, news that we have in immigration field, and then I'll go ahead and answer as many questions as possible. Please click like. That helps a lot to spread the word, to add more viewers to our channel so that we can continue this weekly stream. And please comment, subscribe to our channel, and share the live streams so that we can have more viewers. And thank you very much. I greatly appreciate it. So we will begin. The first news I want to announce that in immigration, the USCIS recently announced that they will probably increase the filing fees for many application forms. That includes adjustment of status, which has a substantial fee hike. So they proposed the new rule, which is currently open for comments. And then according to federal regulations, the public comments are open for 60 days. That will be until beginning of March, and then they can publish the final rule, whereby increasing the filing fees for many forms of immigration applications, including the citizenship, the adjustment of status, the marriage-based adjustment of status, and so on, work permits, travel authorizations. Some of the fee increases are very substantial. For example, right now, if you file an adjustment of status, you file it together with the application for work permit and travel authorization, and there are no additional filing fees or expenses related to that. But they will change that. So they're proposing to require a separate filing fee for work permits that are based on the pending adjustment of status. For travel authorization, they're also proposing increasing the adjustment of status filing fee itself by $400, which is about 30% increase, because the current filing fee for adjustment of status is $12.25. So in the context of, for example, the marriage-based case, that would mean almost doubling the fees. They are significant now. They're about $1,760. But down the road, it's going to be close to about $3,500 or so. So if you are thinking about filing for citizenship, naturalization, or for adjustment of status, and if you're eligible, do it now. Don't wait too long. In the other news, I wanted to talk to you about this week's hearings we had in the asylum cases. We had an asylum case, and I made a separate video about this case that we will probably post. Our marketing team will post. But I wanted to share this news. We had a case which lasted for several weeks. It was an asylum case involving an individual who worked in law enforcement in one of the post-Soviet countries in Eastern Europe, and at one point they didn't obey the orders of higher-ranking officials, as it happens in many of those countries, where they were trying to engage in some corrupt schemes, and this individual didn't agree to join and do this, and that's why then he was subjected to persecution. And then part of it also was because of his family relationship. So we had the case this individual arrived in the United States through the Mexican border and was briefly detained and then released, paroled into the United States. The issue was that he moved to the jurisdiction of Georgia Atlanta Immigration Court, which is a conservative court, and I usually don't support forum shopping in terms of there are rumors that this court you'll get asylum in this court, not in this court. Some judges are loyal and so on. That varies, but generally it's a conservative court, and the outcomes are not so good in Georgia. So we asked specifically the court in Imperial, California, if we can keep the jurisdiction there, despite the fact that the applicant moved to another state, and the court agreed. So, and that was very beneficial to us. We had the hearing, and then upon the third hearing, the asylum was granted, and the judge commended the work I did, and I was, not to brag about this, but it was very nice to hear how judge praised the extremely well done work that we did in preparing for this asylum case. But that was successful. That was great. In another case, it's a similar type of case, but it's in another court and different judge and different facts, somewhat similar. I also think that applicant also deserves asylum, but most likely in that case, the judge will deny asylum and will have to appeal and go through this process down the road. What I'm trying to say is that, it happens both ways. It's not that, the same case would have the same results in different courts with different judges, or, also depends on the flow of the testimony and of the, witnesses and evidence provided. So this was good news, and I'm glad that, this client was granted asylum. I was confident that he deserved it. It was a complicated case. That's why it lasted several days. So we will go to questions, and I'll try to answer as much as possible. Again, please post your questions in the chat section. I will address every question as much as I can within the time that we have. We're going to try to wrap this up when the questions are finished, or within 1 hour or so. And if you have any follow-up questions down the road, you can continue posting, or you can comment under this video. The recording will be saved and will be accessible. But one thing I ask you, please do press like and subscribe to our channel and comment. That helps to attract more viewers and allows us to continue this weekly stream. So the first question is, even after I-140 approved, many months have been passed, but no any confirmation from USCIS for interview through consular processing. Very frustrating to see such delay from USCIS, even though country is current list in visa bulletin. Well, in terms of confirmation, so I-140 is approved. The USCIS for interview through consular process. The confirmation has been sent. I assume the NVC processing is delayed in this person's case. So the National Visa Center, once the USCIS approves the employment-based petition, which is EB3 or 2, then the USCIS forwards the case to the US consulate, and it goes through the State Department, National Visa Center, which asks for additional forms and documents that they need to be able to process the immigrant visa. So at some point, there are situations where the process gets stuck between the USCIS and NVC. And sometimes you may have to prompt them to do it by making inquiries, sending inquiry to NVC or to the State Department or to the USCIS. Nowadays, everything gets transferred digitally. In the past, they actually were sending the file, and there used to be lots of instances where the USCIS would claim that they sent the file, the NVC would claim that they never received it. So in those situations, obviously, it was much more difficult. But do make inquiries with the NVC. There is a public inquiry page. If you type on Google NVC inquiry, it will show up, that link, and you can go there and make the inquiry with the NVC. And same with the USCIS to confirm that they actually sent the case to the NVC. Okay, please do video for DV 2023. What at NVC mean? What is expected to do advanced applications process in 2023? Thanks. So the diversity visa 2023, it started from October, the applications, the either adjustment of status or the consular interviews began. They are advancing forward, actually fairly quick, because we do have several clients with diversity visa who are selected through diversity visa for whom we're filing adjustment of status cases. And the priority dates are moving forward, gradually moving forward. But in terms of what NVC, I mean, the question, it's not clear to me as to what this individual is asking, but if you're in the United States, you can file for adjustment of status. If you are abroad, you will have to go through the consulate. And to do that, once you're selected with diversity through diversity visa lottery, through green card lottery, you must prepare and file the S-260 form online. And then once your turn comes, once your priority date becomes current, they are supposed to schedule an interview. Now, once you file the DS-260, you're supposed to receive an email from Kentucky Consular. What is it called? Kentucky Consular Center, KCC. And but they're not very diligent. In the past years, once lots of applicants filed their DS forms, but they never got the email from Kentucky, then the recommendation is to go ahead and file all of the documents required. And there is a checklist of documents provided by the State Department of things that they need to be able to process. So it's a good idea to go ahead and file those if you don't receive an email confirmation and once your priority date is current, or actually before your priority date is current. So it's a good idea to do so. But it's been chaotic in the past several years. Lots of DV winners were not able to obtain their immigrant visas because of the backlogs and pandemic, issues related to pandemic, the closures of the consulates. They were for a couple of years back to back. They were almost no or minor portion of the immigrant visas issued. All right. So let's see. Please also inform about F2B category. I guess the question is about family-based immigrant visa category. I believe F2B is the children of, I don't remember from the top of my head, but I think it's the adult children of permanent residents who are above 21, unmarried. And so the question is, please inform about that. I mean, there is nothing new to inform about it. There is a priority date. So if you filed the petition if you're a U.S. citizen, for example, filed a petition for your child who's above 21, or if you're a permanent resident who filed for a child over 21, or if it's permanent resident filing for spouse and children, there may be some wait time in the process under those family-based categories. And the reason why there is a wait time is because there is a congressional limit, the limit in the law, which says how many green cards can be issued per year under this specific category. For example, for spouses of permanent residents and so on. Sometimes they become current. Those limits are available. Sometimes they're not. So the F2B category is one of those categories. Typically takes, as far as I remember, takes about 6 to 8 years of process or wait time currently for the F2B category. But when the priority date is up, then you should prompt the NVC to begin the process of gathering documents. Okay. The question, I am living in UAE. Can I apply asylum UAE to USA, sir? Yes, you can apply for asylum from any country in the world as long as you are in the US. From what I mean is, as a citizen of the country. So if you're a citizen of UAE, can you apply for asylum in the US? The answer is yes. Now, it's very rare anybody from UAE applies for asylum, not because there is no persecution there, but citizens of UAE are usually very well off, and they don't wander around and looking for other places to live. But if by living in UAE you mean that you're a citizen of another country, but you have residency in UAE, United Arab Emirates, and the question is, if you come to the US, can apply for asylum? Absolutely, yes. And one of the reasons is different from many other countries. United Arab Emirates, UAE, is not a signatory to the UN Convention on Refugee Status. So, for example, if you're a US asylee, you cannot travel to UAE to Dubai with a travel document, refugee travel document, because they don't recognize it. They're not signatory. They never signed the UN Convention on Status of Refugees. So, there is no process for obtaining asylum through this equivalent of what the United States has. Therefore, your life in UAE is not going to matter. And most likely, you'll never become a permanent resident, although they call it residency card in UAE, but you never become a citizen. That's not permanent. It's work related. So the long story short, we've had a lot of clients who were from other countries like Iran, like Pakistan, Syria, that lived in UAE. They had a resident card, but then they came to the US. We filed for their asylum, and we were able to secure their asylum. And all we needed to show that that card was temporary. They would never become citizens of UAE through this process, or permanent residents. Okay, so the next question is it easy to win asylum case for Yemeni citizens if they're holding a TPS? Very good question. But the answer is simple. No, it's not easy or hard. TPS doesn't really matter for the purposes of asylum. The only way TPS matters is not TPS itself, but the underlying reasons why that country is designated for temporary protected status. That, if this country is designated for temporary protected status, then by the DHS, then that means there is war going on, there are atrocities or severe economic distress, and that usually helps the chances of asylum. So whether you're holding TPS or not holding TPS, that's not going to affect your asylum case. But whether your country is designated for temporary protected status will affect your case, simply because the country conditions play a big role in the chances of obtaining asylum. What about F-21 visa in Bangladesh? My spouse been waiting for. I don't know what F-21 visa means. There are. I don't know. I'm not sure what it is. Don't have time to look it up. If you want to break it down, what you're trying to ask, are you talking about F1 student visa? If so, just please put student visa. Then I'll try to answer your question. The next question is, good day. Is it possible to get EB3 from pending asylum? Already 7 years. Employer would like to help me out with EB3. No interview on asylum. Already 7 years. Yes, it's possible. It depends on many factors. When did you enter? What type of visa you had when you entered? What status you had when you entered the United States? Now, in terms of getting your permanent residence inside the US, if you don't have a current status other than lawful presence based on your pending asylum, then most likely you will not be able to adjust your status in the US. And a lot of people ask me why. For simple reason is the word adjustment of status, meaning application for a green card inside the US, assumes that you have a status which you will adjust. If you don't have a status, that means you're not eligible for adjustment of status. The exception to that is, for example, marriage with a US citizen, where whether you have status or not currently doesn't matter. That's an exception to that. Or, if you have asylum, if you get granted asylum. But for those who have pending asylum case, if you have an employer who's willing to sponsor you, or if you get selected under DV lottery, there are good chances that you can actually travel, go get your green card through a consulate abroad, overseas. And you don't have to go to your home country. Obviously, if you applied for asylum, you probably have fear of returning to your home country. So, we have done this in the past. We've done this in several cases where we even obtained advanced parole, allowing the applicant to travel to that third country. But it's a complicated process. So usually by default, if your employer sponsors you, your I-140 gets approved. Eventually the NVC will receive the case. You'll upload all the documents. They'll send it to the US consulate in your home country. In some cases, they send it to the third country if they don't have a processing center there for immigrant visas. But usually they will. Then you have to ask for the consulate in another country to accept your case, because you cannot go to your home country for this because you have, fear of persecution there. And you have to somehow manage to get the advance parole to allow you, from the USCIS, to allow you to leave the US without losing your pending asylum claim, because you want to have additional assurance in case if something goes wrong at the US consulate and you don't get immigrant visa, or if you're stuck there, then at least you can return to the United States with that advance parole. So it's a complicated process. Now, one other thing you need to consider, that if you have been unlawfully present for quite some time before you became lawfully present based on your pending asylum case, then you may incur unlawful presence enough to trigger a ban, a 10-year or 3-year ban from returning to the US, at which point it means if you leave the US and go to the consulate, you're not going to be able to get that permanent residency because of that ban, that immigrant visa. So lots of numbers and thoughts and factors to consider that you need to consult with a lawyer if you have an employer who's willing to sponsor. And most likely your employer will have a lawyer who's going to be handling this perm process. If not, then you can find that lawyer. We will be glad to help, obviously, and that lawyer will, consult you on all of that information. All right, next question is, does the fact that your mother is a refugee in the USA increase your chances of being recognized as a refugee? The answer is yes. And I'm sorry, I apologize. 1 second. Let me do this. Okay. Okay, so the answer is yes. So if your parents were refugees and you have similar basis or somewhat similar basis for asylum application, that obviously increases the chance that, because your parents were refugees, it's likely the similar thing can happen to you, or it at least supports your case one way or another. So, but a lot depends on what was the basis for your parents, for your mother's refugee status. What was her basis for asylum claim? Okay, the next question is, good day. Why is court hearing date being changed for asylum? Well, it happens a lot. So it happens lately quite often. And there are many different reasons for it. Well, it's always been happening. So the immigration courts, just like anything else, any other place, those immigration judges, they have things that happen in their life, whether it's work-related or personal. Sometimes immigration judges get sick. Sometimes they have to be, missing a day from work for family reasons. Sometimes, they're sent to some training, or something happens with them. We get notices through American Immigration Lawyers Association, through for immigration courts. Every day we get notices that one immigration court is closed because of the weather conditions and so on. So those are like short-term notices, changes, sudden changes. Like you may have a hearing tomorrow and then suddenly it gets canceled because the clerk made a mistake and booked 2 hearings on the same time. Or you may get canceled because the judge had some family issue and they cannot attend your hearing. But there are also things that have been happening quite often lately because the immigration courts are evolving. So the Biden administration increased the budget. They hired lots of new immigration judges to reduce the backlogs. They have opened new immigration courts. For example, here in Virginia, there used to be Arlington Immigration Court. Now there is Sterling and Annandale, 2 immigration courts. They hired a lot more judges, expanded those courts. And when this happens, those judges who have your case in their docket currently, they move around, they pass it to another judge, to a new judge, so that they try to balance out all of their workload. And when this happens, your hearings get canceled. And sometimes they get canceled and they get pushed to a much further date. And you may think that that's not logical, because if they're improving it, then you should have your hearing earlier. But what happens is they do that, and then a month later or so, you get another notice, and it's a lot earlier than before. So yes, the cases get canceled, moved around, pushed around, and that happens. Bear with it. I mean, there's not much you can do. Now, if your immigration court case, your hearing is rescheduled to much further date in the future, and you want your case to be heard earlier, you have a chance you can file a motion to advance your hearing. If you have strong basis, the judges liberally grant that motion, but it doesn't automatically mean that you will get that done. If you ask for advance date for your hearing, one way it gets done is the clerk, tells the judge that, oh, we have this cancellation 2 weeks from now. Maybe we can put this case in there. So filing a motion to advance to expedite your immigration court hearing is always helpful. Just make sure you don't make up any, non-existing basis for it, because it will damage significantly your credibility in the case. But do file it, even if your case has been pending for many years and now rescheduled, and you're just saying, please schedule it for an earlier date. It's been too long. You can still do so. Maybe the judge will deny the motion and say, no, just wait in line, but filing it wouldn't hurt. And, if your attorney can establish contact with the clerk or the judge and kind of notify the clerk that, hey, we're ready to proceed. If you have any cancellations or windows open, we will be happy to take it the first available date. And sometimes they do. We had even a situation where I had one client who didn't mind his hearing to be heard later, and I had another client who wanted her hearing to be heard much faster. So we basically swapped with the same judge. So I contacted the clerk and said, I have a hearing 2 weeks from now. This client doesn't mind giving his spot to this client who wants her hearing much faster. And we worked it out with the clerk of the judge, and we're able to do it. So what I'm trying to say is that there are many creative ways to get your hearing faster or later. And, you should talk to your lawyer and work with him or her on that. Okay. Does the fact, the court hearing being changed for asylum will schedule appointment to your office. I know it's conducted online or over the phone in next week. Thanks a lot. Okay, thank you very much. Yeah, we'll be glad to help you. All right. Yes, the mom applied for asylum and was granted. Her kids was granted too, but the home country refused to issue the travel documents for the children unless the mom come back. Okay. So I assume that's a continuation of the question about if your parents were granted or if your mother was granted asylum. Does that help you? Yes, so it does help, but I think that question is not about that. Here, what this person is asking is saying, mom applied for asylum and was granted. The kids were granted too, but the home country refused to issue the travel document for the children unless the mom come back. So the children are stuck without passports, and the mother got asylum here, but they cannot travel because they don't have passports. And we have a similar situation in a case that we talked about yesterday. It's a case from China. It's one of the individuals from Uyghur ethnicity from East Turkestan who don't have, the husband is here. He has not asylum in this case. He has a permanent residency through family reunification he somehow got, but his family is still in China, and we all know about what is going on, with genocide against Uyghurs in China. But so this is his wife and child are in China, but they're not being issued passport, which China does frequently now. Actually, consistently to Uyghurs, they don't issue passports, so they cannot travel. So what happens now? The answer is that if you don't have a travel document, if you don't have a passport, the U.S. State Department, U.S. government, consulates make exceptions. In extreme situations, they allow to travel to basically get your visa, immigrant visa or non-immigrant visa, or boarding foil, which is, in the case of asylees, they grant those without a passport. So, for example, for Ukrainians recently, the official government announcement was that the Ukrainians can travel to the US without passports because of the war. Lots of refugees didn't have it. Now, I haven't seen official announcement currently for Uyghurs from China, but we were able, in one of the cases, not for the travel document, but with a marriage certificate, we were able to get an exemption because it was just virtually impossible to get that because of the restrictions put by the Chinese government. So to answer this question, it's possible to get an exemption, but how are they going to leave the country of their persecution? The US cannot get involved. And that refers to a lot. Sometimes people ask me, can I apply for asylum abroad, even though I'm not in the United States? You may have basis for it, but the US is not going to get involved in extracting you from the country of your persecution unless it's in its substantial US interest. So we've seen, in the movies, and you've probably heard stories of the United States extracting someone from their country, or the embassy accepting an asylum applicant, but there is no procedure for that. Those are exceptions, not the rule. Okay. The kids find the way to come to USA, want to apply for asylum. Yes, so they somehow need to come to the USA, but the kids also, they don't need to apply for asylum separately. They can, if their mom was granted asylum, the mom can sponsor them for asylum by filing the Form I-730. It's unfortunately, it's a lengthy process, but that can also be expedited. So they don't need to file a separate asylum application by themselves. Okay, so let me 1 second. The next question I have is, guys, I see that there are some viewers. If you have any questions, if there is anything you want me to tell you about, please post your question on the chat section of this video, and I will answer as much as I can. Okay, the next question is wasted family category. Annual visas needs to be recaptured to clear backlog. Okay, yeah, I mean, yes, so they need to be recaptured to clear the backlog. Unfortunately, the State Department is not as consistent as they could be in recapturing those wasted family category or employment-based category. Sometimes they do, and sometimes these priority numbers progress, but sometimes, unfortunately, they retrogress those priority dates. So we've had situations where some of the family cases were retrogressed, like spouses of permanent residents, and sometimes they were progressed forward because those wasted or unissued annual visas were recaptured. Okay, so I don't see any other questions at this point. We've been going on for 35 minutes. That's usually shorter than usual, but if anybody has any questions, please post it in the chat section. I will answer. If not, then we can wrap it up here, and we'll probably have another video next Thursday. So we try to do it on weekly basis, every Thursday around the same time. But I will see. I'll see if we can do it, because sometimes it conflicts with hearings I have, or client interviews, and so on and so forth. Okay, so I got 2 more questions. Hello, sir. Please, what is the processing time of I-730? It's a lot. So the USCIS, as you know, has processing times posted online. So you go online, you Google processing time, and then you put the form number and the location where the case is being reviewed, and they post the processing time. Those processing times give you a very rough estimate, so they're not very accurate. And sometimes they post a range, which is a very wide range, which basically is not helpful. But based on the experience on I-730 cases, which we frequently handle, I would say it's about 1 year. But in a lot of cases, these I-730s can be expedited. Because what is I-730? I-730 is the application by the asylee, somebody who was granted asylum in the US, to bring their immediate family members from their home country. So could be, wife, children, and so on. Or if the family member is here in the US, then they file it. Then this processing time, it doesn't really matter as much. It does for eventually qualifying for permanent residency. But once you file it, that person is here. They're basically almost like waiting for asylum. But as I said, most of the time, if your family members are abroad, this can be expedited. And the reason it can be expedited is because if you were granted asylum, probably there are things going on in your country that are threats against you and possibly your family members. Maybe they're being harassed. Maybe it's dangerous conditions in your home country. In that case, this I-730 can be expedited. If it gets expedited, it usually is done within about, instead of 1 year, year and a half, it will take about 6 months or so. And you have to expedite it on each stage of the process. So when you request an expedite with the USCIS, where the I-730 gets filed first, once they do agree to expedite it, and then the case goes to the National Visa Center, State Department, then you need to contact the consulate and the NVC and ask them to expedite it as well. So you should do the expedite request at each stage. And if you do, then it can be much faster than 1 year. All right, next question. I have a question why the people that ask for a political asylum has more privilege than me. I work here in the United States, and pay taxes and been here for 31 years. I think there is a big misunderstanding about privileges for asylees or for individuals crossing the US border, or some undocumented. There was this, I think it started anecdotally, but people are still talking about this, that somebody who's been undocumented has better chances of qualifying through amnesty and so on versus somebody who's been employed here paying taxes and so on. That's absolutely 180 degrees false. That's fake news. That's never been so and never been the case. And there is a misconception about the asylees. The asylees don't have more privileges. What they have is they have protections, because if you are for example, if you're here working, right, you're paying taxes and so on. If you become a permanent resident through this process, or you have a work visa, you're free to travel to your home country, meet your relatives, be there, visit your country. But the asylees cannot. So, if you talk about privileges, I don't think the asylees have privileges. I think you have better privileges. This asylee is stuck here. The asylees wait for years until they get that protection. And the reason why they get that protection is because they are being persecuted. They have been subjected to torture, threats, beatings, arrest. Their family members may have been killed. They've been crippled. Many things can happen, or it could be a real possibility that this will happen. So they have those bases. They have those risks. That's why United States gives them those protections. It's not because they are chosen to be given those protections. And by protections, what it means is that they get to, for example, apply for a travel document which will substitute their passport. They cannot use their home country's passport. But hey, if you think that you qualify for those things, you can get both. You can have your work visa, work here in the US, pay taxes, and enjoy being able to travel and so on. And you can apply for asylum too, if you think you qualify. And the good news for you is that those asylees who apply for asylum, or asylum applicants whose case gets denied, they're going to be put in removal proceedings, and they'll be one step from being removed, away from being removed from US if they are not qualified for asylum on the first stage. If some college graduate from asylum office doesn't believe that this person qualifies for asylum, this asylee family is going to be placed in removal proceedings, and under fear of being removed from the United States or detained before being removed. Where in your case, you have a much better privilege, because you can apply for asylum as long as you have basis for it. And if you don't get granted asylum, that's fine. You're going to be back to the same spot you're in now. So please don't fall into those fake and misconstrued notions that undocumented aliens or individuals arriving into the US through the border or crossing the border illegally, or asylum applicants have better life or better privileges or options than those who come in legally through visas or have work visas or student visas and so on. No, they don't have a better options, better lives. They have much more difficult paths through these procedures to their citizenship or permanent residency than many others do. Now, case by case, there are exemptions. I mean, somebody can be selected through diversity visa lottery and become a permanent resident much faster than somebody who invested $1 million and hired 2 or 10 US workers, right, through EB-5 process. So should we complain that there is a lottery system? I mean, some do complain. Trump administration did. So anyways, I think I went too far but answering this question, but no, asylees don't get more privileges than those who, have, for example, work visas. After a Stoke interview, how long does the case take to review? What is Stokes interview? Stokes interview is a second interview at the time of adjustment of status through marriage. So that is typically what happens is if you go to the USCIS for a marriage-based interview, which nowadays they're waiving, they're not scheduling interviews. Most of the time they're approving cases without interviews. But once you go there, typically the spouses are questioned together. They may be questioned about their relationship, how they met each other, and so on and so forth. But if the officer has suspicion, some red flags, they can either do the Stokes interview right away, or they can do a second interview where they will question those spouses separately, and then they will compare the answers. Now, there are lots of myths about that Stokes interview, that the second interview or the separate interview to question the marriage. There are lots of myths, there are lots of misconceptions that, this is what happens. They put you in the room, to separate rooms and so on, but that doesn't happen that way. No, so then usually the same officer asks the same questions, and there is nothing mythical about it. They ask questions that make sense. For example, the officer can ask what you had for breakfast this morning, right? So if one spouse says we had an omelet, the other one says we had, pancakes, maybe they had omelet with pancakes and one of them forgot. So that could be explained if the question comes up. But if they answer give completely different answers, then they probably lied that they lived together, that they woke up together. Now, that's an example of questions. You can imagine there are thousands of other questions. So after the Stokes interview, they compare those answers. They give a chance. They must give the chance to applicants to clarify any inconsistencies or mismatches in the answers. And as I explained in the sample of pancakes with eggs, as long as it can be explained, then that's fine. But it takes time for the officer to review this. And if there's been a Stokes interview, that means Stokes interview, well, is it Stokes? I think it's Stokes interview. If there was a Stokes interview, and it comes from the name of the case, I believe that's how the Stokes interview is called. If there's been a Stokes interview, then that means there were some red flags, there were some concerns with the case, and that means the officer is going to take some time to review all of that and to address all of those questions. So to answer your question, Ms. Watson, it may take significant amount of time. We've had cases which took a year or more after the interview. Of course, you can make inquiries and continue pushing, or you can make an inquiry with the USCIS field office. You can make inquiry with the USCIS ombudsman's office. You can make a request through your congressional representative, congressmen, senators, and that sometimes helps. And if it does take too long, and by too long I mean more than 12 months, you always have a right to also file. Typically, we say that 12 months or more. You want to do all those inquiries first, and if it still doesn't work, then you also have a right to file a federal action in federal court against the USCIS. That's called a mandamus action. That's basically you are telling federal court to order USCIS to do their job, because what most likely happened if your case is stuck for too long is because the USCIS officer who did the Stokes interview may have been rotated or quit the job, and then the new officer doesn't want to touch that file, so there is a pile of what we call fishy files, like smelly files that the new officer doesn't want to touch, open, and then it sits there until some court orders them to take action, or some supervisor through those inquiries makes the new officer to open and look at it. So things happen. There is no way to predict exactly how long. So next question. My uncle applied for mom in 2010. Now, can I expedite F4 category as both are getting old? No, absolutely not. So I'll give you a brief answer. No. These categories, the priority date categories, cannot be expedited. The only way expedite is the processing time, but not the wait time. The queue, the line you have, the limits on number of green cards issued based on for F4 category is determined by the Congress. So the only way to expedite is to get the Congress to change the law and to come up with larger number of green cards under this category. Okay, thank you very much, sir. Thank you. And thank you so much. Thank you for listening. Okay, next question. I am from Iran, and because of what is happening, my goal is to come to USA. I even know what state I want to go in. That's great. It's good to have everything planned. Because of our currency value drops, it gets hard to go somewhere. I am 27. What are the options for me? It's very broad and general question. You need to first narrow down the options that you want to talk about. I mean, I don't know you. I don't know much about your background, whether you have an employer, whether you have money to invest, whether you want to start your own business, whether you have a family member here. So my recommendation is go ahead and review different categories of immigration, different options of immigration into the US through readily available public sources like our website, for example. It contains all information about almost each option of immigrating into the US. Review that free information, narrow down your questions as to which category you want to talk about, and then contact a immigration lawyer and schedule a consultation. You will need an individual consultation because I cannot tell you about all of the options in this video, and I cannot answer a case-specific questions to give you the full information about what option will work for you. So you'll need a consultation, but before you do consultation, I do urge you, please read the readily available so you use your consultation as effectively as possible. The time that you will have for this, you will use it as effectively as possible. So you don't want to talk about some category, possible way of immigration into the US, which has nothing to do with you. Okay. Next question. I'm from Egypt. I was thinking of using my twins passport to get into the US, then ask for asylum. I'm an atheist. Would I be immediately deported back to my country, or would I have a chance? Now, I don't know if the question is, would you be deported back to your country because you're an atheist, or are you asking whether you will be deported back to your country because you used a fake passport? The answer to both questions is no. So in the context of asylum, how you enter the US to apply for asylum, to escape the country of your persecution, to save yourself, your freedom, your health, is not material. So you will be forgiven if you qualify. If you demonstrate that if you didn't use a fake passport to enter the US, you would be subject to persecution, then that's not going to negatively affect. I mean, it may raise a question, but it's not a bar to your asylum. It's not going to prohibit you from qualifying for asylum. So in the context, and a lot of people don't know this, and that's one of the traps they fall into. And how they fall into this trap is, I will explain. So at the asylum interview, I think I discussed that in the previous video, in the previous live stream. At the asylum interview, one of the questions the officer will ask you for sure is, have you ever used false information to obtain immigration benefits, such as immigration visa, to enter the U.S. and so on and so forth? And a lot of asylum applicants do that, just like this person who asked this question. People use fake passports and fake visas or fake documents to get visas and so on to come into the U.S., or they just cross the border illegally. In the context of asylum, that is going to be forgiven, meaning it will not bar you from obtaining asylum because it's understood that morally that to save somebody's life and for health or safety of their family themselves, they can use those type of means. But at the asylum interview, the officer will ask you that question. A lot of people think that, oh, if I tell them that, I used or I gave the fake document to the consular officer when I was obtaining B2, B1 visa, then I'm going to be become not eligible for asylum. But that's not so. But they also don't know that the consular officer makes those inquiries and already knows, because the asylum officer. So the asylum officer obtains all of your records from the U.S. consulate where you got your non-immigrant visa before entering the U.S., and they have all that information. Not only the CBP and so on. So anything you told them, gave them, they already know. So they ask this trick question, knowing that you provided a false, for example, employment verification document or a false bank statement showing you had money. Knowing that, they ask you, have you provided any false information? Why do they do that? To test you, because most of your result of your asylum case depends on your credibility. That's the biggest part of your asylum case, is your credibility, because your testimony is I would say, most important part in your asylum case. No matter what type of evidence you provide, certificates, witness statements, and so on, that's not as important as how you testify and your credibility. And if you're found credible, what you say becomes truth, becomes evidence. And if you lie to the officer today that you did not provide any fake information at your consular interview for your B2, B1 visa, then you are damaging your credibility, and everything you said, the officer is not going to believe. So don't fall into that trap. But yes, so using twins passport to get into the US is not going to bar you from asylum. You may be eligible for asylum. And then being an atheist also is not going to bar you from asylum. Being any member of any religion or denomination is not going to bar you from asylum. And I've had clients who, were afraid to write their religion in the asylum application form, even though the case was not religious based. But they were like writing, no, I'm not religious. And I always ask them, are you doing this because you're afraid that, if you're Muslim, that somebody, lots of asylum officers are Muslims, and, some of the asylum officers are women with hijab, and they're Muslims. And you don't want to, that's not how United States. I mean, if you think in the United States you will be deported because you're Muslim or atheist, then why do you come to the US? Then, you're going to be persecuted here too. But that's not how it works. Unfortunately, there are instances, there are some people who have biases and so on, but it goes both ways. There are people who have biases. There are people who have positive biases. They have, they're overly sympathetic. And if you say I'm an atheist, and if you're not atheist, then it can hurt your case. The bottom line is, if you're atheist, say you're atheist, and you're not going to be deported because of that. Okay, I asked because my aunt did a family petition for me. Well, that's a different person. Well, I guess it's a previous question. So I have a valid, unexpired green card, and my SB1 visa application was denied. 2 weeks ago at the U.S. consulate where I am, can I still fly back into the U.S.? What are my options? So if you have a valid unexpired green card, when you say SB1, I assume the returning resident visa. That was not a good idea to actually apply to the returning visa, resident visa through consulate, which often gets denied. Then you're kind of stuck. I mean, if it's denied, the U.S. government thinks that you already abandoned your permanent residency. What I can tell you is, coming to the U.S., you can, and only the federal judge, immigration court judge, can take away your permanent residency, or you will need to sign a waiver. Now, how does SB1 visa application denial affects it? I don't know. That's something I'll need to look into before I can give you the exact answer. My recommendation is, do consult with a lawyer one-on-one to get the full answer on this. But the next question on the same person is, what happens if the CBP confiscate my green card at the port of entry? What are my options? So here's what happens. If you enter the US after long absence, even if your green card is expired, you will be allowed into the US. They can confiscate your green card, but they have to give you a summons to appear in immigration court to show that you did, even despite being absent for so long, you never abandoned your permanent residence in the US. If you have no way of showing that, then you're risking of getting, order of removal because an immigration court or your green card is going to be taken. Then you will be unlawfully present, you have no status, and you can be ordered removal. But if you have ways of fighting this, then the procedure is that CBP can confiscate your green card. They'll call you to immigration court. You have to prepare and defend that despite your lengthy absence, which creates that presumption you abandoned your permanent residency. You never did. You always intended to live permanently in the US. You're right. I want to start business, but I want to be hired so I can work somewhere. Okay, that's the continuation of the previous question. I can't go on. I want to make sure that we answer all other questions. But yeah, so I know programming and content writer, AI, cybersecurity. So if you do, then it's a good idea to look for an employment. The cybersecurity, AI, content writing, they're very hot topics here in the US, and you may find an employer who may be willing to sponsor you for a work visa, and then maybe work visa might be a good option for you. Okay. Thank you so much for the detailed answer. Thank you for listening. Is there an immigrant visa for religious workers? Yes, there is immigrant visa for religious workers. There is non-immigrant visa and immigrant visa, and they're quite easy and fast. So if you have a place that you're going to be working here in the US as a religious worker, we do that frequently. Get in touch with us. First, you'll need, again, place an employer who's willing to sponsor you. Okay, the next person answers, I'm indeed an atheist ex-Muslim. Understand. So that's fine. And if because you don't want to be a Muslim, you don't want to obey the Islamic rules, if you were persecuted, if you were threatened and so on, because of that is that might be a good case on religious basis. On the religion basis might be a good case for asylum. Thanks, and thank you for listening. Hi, thank you for your information. My wife applied affirmative asylum last April 2022, and we did biometric. I'm on H-1B status, and my wife on H-4. I was planning to apply for EB-2 NIW green card application. Very good, that will work. So you can maintain your H status, your work visa, H-1B and H-4 status, while you have a pending asylum application, as long as you didn't misrepresent, use fake information, as long as you didn't file a frivolous, baseless asylum application, that's not going to hurt. And you can apply for a green card based on EB-2. And guess what? Even if you become a permanent resident, you can still keep your asylum application pending and even qualify for asylum as a permanent resident. A lot of people don't know this. Because as a permanent resident, all you get is a permission to remain in the US permanently, to work here, travel in and out. But you don't become a citizen of this country until 5 years after, or you don't get the protections as a refugee. But asylees do get those protections. And one of those important protections is a travel document. So for example, in this scenario, you have H1 status, H4 status through your wife, and you're planning to apply for national interest waiver green card. And let's say you do get that green card through national interest waiver. Let's say now you're traveling to some third country. You're traveling to UK for a vacation. Which passport you're going to use? You're going to use the passport of your home country from which you are asking asylum, from which you fled, to which allegedly is going to persecute you. And if in the UK you get into some issue, and well, I mean, I kind of brought example of UK, which is a kind of extreme example, but if you go to another country which may have some extradition treaty with the country of your persecution, or if you get into trouble there, then you will be considered a citizen of that other country, not of the United States. So you may run into those issues. And if the country of your persecution issues an Interpol red notice, so despite being a permanent resident in the US, you're going to have an issue of that country trying to extradite you, through this red notice, which is significantly abused by lots of authoritarian regimes. Bottom line is, for the purpose of chasing dissidents, but bottom line is, don't just abandon your asylum claim just because you have other means of becoming a permanent resident. Talk to a lawyer. Might be a good idea to still get asylum and have these extra protections. I found the church who's going to sponsor me as an immigrant visa. What are the basic requirements? Well, I think we're not here to go through the case requirements. I mean, if you want the basic requirements, you can go online. It's an R visa, is the non-immigrant visa, and it's Form I-360 for the immigrant process for the religious workers. And the USCIS has a lot more detailed information that I can tell you in this brief answer within a minute. So it's a better idea to look through that detailed available channels for that. Or if you want a detailed specific consultation about your case, then you can schedule one who will be glad to help. I'm not trying to avoid giving you the information. It's just I don't have that list of the requirements and documents in front of me. The requirements is you have to be a religious worker and you have to have a sponsor. Now, what documents are required, what you need to prove, it's a lengthy process to explain. What to expect in court after approved VAWA. No criminal record filing for I-485 in court, the question mark. No, you don't have to file I-485 in court. That's the good news. You can get your case terminated. If you got VAWA approved, your I-360 is approved. VAWA means Violence Against Women Act. So that means you are a spouse of someone, a U.S. citizen or permanent resident who abused you during your relationship. And because of that, you qualify for that Violence Against Women Act exception, and you can file for adjustment of status for permanent residency based on that. But in court, you don't want to do it because the process through court may be delayed unless the court tells you, and you can check that with the judge, with the judge's clerk, that the hearing is going to be very soon, in which case it might be beneficial to do so. But other than that, if you want to do it without having to wait through the court process, because it may take years, then you may want to talk to your lawyer, will talk to the government attorney and try to get your court case closed, terminated, so you can file normally with the USCIS. Okay, thank you. Okay, let's see. Okay, couple more questions. Actually, 4 or 5 more questions. I'll try to answer as quick as possible. We are now past 1 hour. What to expect? Okay, that I answered. Hello, thank you. I have a 10-year green card, which is about to expire. I travel back and forth to home country, Russia. Okay, how is the green card extension application process, and can it be denied if I stayed a lot time outside of US? Typically not at the time of extending your green card, the Form I-90. They don't, question necessarily how long you've been. There is a question in the form, as I understand, about your travels, but it's not about that. I mean, you have to understand the green card extension is the card. The green card is just a card. It's like if your passport expires, you don't lose your citizenship. Same thing when your green card expires, you don't lose your permanent residency. It's just the card expires, except for the situation with the 2-year conditional residence. In that case, yes, your residence expires. But with a 10-year card, if it's about to expire, you renew it, you file the I-90 form, and you'll have a receipt. You can travel with that receipt. But you're going to have the issue with absences or frequent absences, no matter what, unless you file for re-entry permit. So if you are traveling a lot abroad, you're a permanent resident, if you're planning to be there for lengthy periods of time, or if you're going to be traveling a lot back and forth, it's always a good idea to have as a backup re-entry permit. Re-entry permit is a simple process. It's a pre-authorization to be absent from US for up to 2 years, can be extended for another 2 years, and then in increments of 1 year, which allows you to avoid being questioned about the lengthy absences and frequent absences as well. And there is also a misconception. People think that if you come back in the US every 6 months, you're good to go. No, you'll still have issues at the border if you do that too frequently and spend most of the time outside of the US. Okay, thank you. One more thing, how to apply for a job. Even in Iran, we don't have any embassy. It's not something I can help you with, unfortunately. You can contact the employment agencies or look online for job announcements. I mean, if the employer is really interested, if you're qualified, they may be willing to sponsor you. And that happens. It's not a mythical thing to find a job while you're there here. As long as you qualify, maybe you can start remotely working with the employer, if you're in IT field, and then maybe, they will want to sponsor you down the road. How long does it take for USCIS to follow up with you after an email receipt to expedite? Email receipt to expedite, how soon? Nobody knows. So typically, we get a response within a month, within several weeks, saying whether expedite is granted or not. Sometimes it's just a black hole and we never get a response. The problem with expedite requests is that expedite requests themselves now got backlogged because of the number of expedite requests. Because of the substantial backlogs, the USCIS announced expedite process where you can place those requests. And a lot of people began abusing it by placing expedite requests without really having the basis, even though they tried to specify specific criteria for it, such as significant humanitarian reasons. But a lot of people, just applicants, began applying for expedite requests without real basis, or maybe they thought they had basis. And that process in itself got backlogged. All right, thank you very much for your important answers to my questions. Thank you very much for your questions and for listening. Again, if you have any follow-up questions, please comment at the bottom of this video. It will be published, and thank you for joining us. We'll try to do this. This is the third week, I believe, and we're going to try to do it next Thursday. If not, we'll pre-announce it. So follow the announcements as to the date and time. Prepare your questions, and I will be, excuse me, my throat dried. I will be happy to answer as much as I can. Thank you very much, and have a nice rest of the week.